Hi, my name is Miss Barbosa, and today we're going to talk about copyright. So first off, what is copyright? So copyright, as defined by the U.S. Copyright Office, is a type of intellectual property that protects original works of authorships as soon as an author fixes the work in a tangible form of expression. So, in other words, copyright is the legal right of the owner to their intellectual property. And based off of this definition, it has to be something not just that you are thinking about or that is just something you've said aloud to someone else, but you've actually made the work yourself. It's original and it's something that can be touched. So, for example, like a photograph or a written piece of text, just a tangible form of expression, meaning that you can actually see that work. So, why should you care about copyright? Copyright is because that means you have rights over your original work. As soon as you create something, or as soon as someone creates something, that is copyrighted to them. Think about, if you are drawing something yourself or you have written a awesome poem and someone else takes credit for it. Well, that means that they are infringing on your rights because that is your original work. That is not something that someone else created. So I talked about infringing. So infringing on copyright, which means that like you are not respecting that copyright, can result in paying a fine, which is also known as a civil liability, and you can pay up to $750,000 for infringing on copyright. You could also go to jail, which is also known as a criminal liability. You can spend up to 5 years in jail for copyright infringement. Both of these penalties depend on how severe or what a court judges. So these are big reasons why you should care. And again, like I said, everyone is a copyright owner. So once you create an original work, you are the author and the owner. So if you create something, it's copyrighted to you. If you want to take extra steps to protect it, you can actually register your copyright with the US Copyright Office. But you do not need to register it for you to have copyright over that. So we talked about things that can be copyrighted. So, like I said before, remember it has to be a tangible form of expression. So that means it could be like a photo, it could be a story, it could be illustrations, cartoons, ads, sound recordings, works of art, musical compositions, computer programs. Any of these things can be copyrighted. Things that cannot be copyrighted, that would be something like ideas, facts, concepts, ingredients. So those haven't been tangible yet. You're just kind of talking about them. Also, facts can't be copyrighted because those are just things about the world that are true. Same thing with concepts. Ingredients can't be copyrighted either because those are the things that we use to make others. There's also these on the right hand side for they have the little asterisk, so that's names, titles, short phrases, and slogans. That's because they do not contain a minimum amount of authorship in an original work. So, for example, you know, it is very possible that you have the same name as someone else in this world, and nothing results in legal action because of that, because your name is not copyrighted. Titles are also not copyrighted. So, for example, that movie Frozen that everyone was super excited about. There's another movie called Frozen, not the Disney version, but a horror movie about like a ski adventure gone wrong. They have the same title because those things are not copyrighted. The work in those movies is copyrighted, but the titles are not copyrighted. The same thing is like with short phrases or slogans. So you can't say like that you're going to copyright the phrase, okay, sounds good, because that is just a phrase that everyone uses. Slogans, the words themselves can be copyrighted. So like a good example of this would be like Nike, just do it. You can't copyright the words just do it. However, Nike took just do it, put it with a check mark, and it became their trademark and logo. So that isn't necessarily copyrighted, but it can be trademarked, which is a different type of intellectual property. Other things, so federal works are also not protected by copyright. Federal works means that these are things put forward by the government. So, for example, I have a photo here on the left-hand side taken by NASA. NASA, as we know, is the government's space exploration program. that is not copyrighted. It is open to the public. Things like the United States Constitution, like right here is the Bill of Rights, and this is from the National Archives. That is also not copyrighted because the public owns it. And then we also have like federal press releases. All of these are not protected by copyright, which kind of gets us into the next thing, which is public domain. So these are creative materials that are not covered by intellectual property laws like copyright, trademarks, or patents. The public owns these works, so not a single individual. And that's like the ones I showed before, the government things. Things also can go into the public domain after a certain amount of time. So, as a general rule, especially for works created after 1978, it is the lifetime of the author plus 70 years. And then after that, copyright expires and works go into the public domain. You can typically see it with like the logo seen up here with like the C crossed out. That's public domain. You might also see the symbol here where it's like a 0 through with this public domain dedication. So this just means that it enables scientists, educators, artists, and other copyright protected owners to place them as completely as possible in the public domain. Another one you might see is the PD sign. So that's a public domain mark. It means that these are works no longer restricted by copyright. So for example, we're coming up in, it's the year 2023, works that, many of the works right now that are in the public domain are those published before 1923. You might see those with this PD mark. You might also see the stuff of the things entering the public domain after the, the amount of time of the author's death passing and the 70 years are passed. We have Creative Commons. So Creative Commons is pretty much all the possibilities that come between full copyright, which we talked about at the beginning, which is all rights reserved to an individual, and public domain, which means that there's no rights reserved and the public owns it. So Creative Commons are pretty much all the things in between those two extremes. They allow copyright holders to retain some copyright rights, but also allow some uses of the work. And those depends on the type of Creative Commons license and the attributes. So these 4 symbols here at the bottom are the attributes. So this first one is attribution, meaning that you say who created it, like who's it by. We have the second one, non-commercial, which means that it can be shared with other people for, information purposes, educational purposes, but not commercially, meaning you won't be making money off of it. The next one is no derivatives, meaning you can only share that work as it is, you cannot change it. And the last one is share alike. So that means that anytime if you do make changes or you share it, you must share all of the information from that Creative Commons license with it. So they can be put together in a different number of combinations, and these are the 6 types of Creative Commons license. So you have the by, which is attribution, like I mentioned. You see that one here on the left-hand side of by NYC, which is up on the top right-hand side. So you need to give the attribution, and it's also for non-commercial. We have by SA, attribution and share alike. That's the second one on the left-hand side. Next, going to the second one on the right-hand side would be attribution, non-commercial, and share alike. Over on the bottom, we have the attribution and no derivatives. And then last but not least, we have attribution, non-commercial, and no derivatives. That's going to be the most restrictive of the Creative Commons licenses. Pretty much the easiest way to determine the copyright is to look at the documentation on the work itself. Those things I just mentioned before, all the attributes, will clue you in onto the copyright. It will also tell you what the copyright date is. Okay, I get it. Copyright is important and I need to be aware of it. I still need to use copyrighted material. What if I need to use something for an assignment, or do I really need to have permission to use everything? The answer is yeah, kind of. So how can you use copyrighted materials? So one way is to get permission from the copyright holder. So that would be, first you need to identify what type of permission is needed. That's where the attributes come in handy. That's where you need to know what the copyright is. And then second, you would identify and locate the copyright owners. And last but not least, negotiate permission. Are you able to use the copyright? And this is more important especially when you're trying to get a specific type of license. For our purposes, we're going to be focusing a little bit more on the second one, which is fair use. So fair use is a statutory exemption, meaning that it's kind of like written into the law. So that's a copyrighted work which can be used without permission, but it's not just for anything. There's specific circumstances. Excuse me. So with fair use, Section 107 of the Copyright Act provides a statutory framework for determining whether something is a fair use or not. So we have criticism and comment. So that would be, are you trying to make a criticism based off the work? Are you commenting on the work, how it is? That would be an example of fair use. If you are reporting for something on the news, that is also a good example of fair use, because you're not using it to try to commercially use it. You're just trying to report on it. We have teaching and scholarship, which falls under a lot of educational uses. That would be a good example of when something can be used for fair use. And the last one is for research. Okay, perfect. You might be thinking to yourself, I'm a student. I need to use this for scholarship or research. So it means I can use as much as I want, right? Yes and no, not quite. So there are 4 factors of fair use that you need to consider. So there's the character of fair use. So yes, you are using it for educational purposes, and it's more likely to be used, considered fair use in educational rather than commercial or entertainment purposes, but that is only one of the things. The second one is the nature of the work. So in this case, stuff that is trying to give you information, so like nonfiction published pieces, are more likely to be considered fair use as opposed to like stories and creative properties. Third is the amount of the work used. So typically, if you're borrowing a smaller amount over a larger amount of copyrighted work, that is more likely to be considered fair use. And which, I mean, makes sense. If you are trying to show your point from a 30-minute video and you only need 3 minutes, then use the smaller amount, the 3 minutes, as opposed to trying to show like 30 minutes. And that one's pretty easy to understand. That's what we would consider quantitative, which is just the amount. But it's also measured qualitatively, which has to do more with like the heart of the work. So that would mean something along the lines of like what it really captures, what the work means. And that one can be a little bit tricky, because if you are using things from the heart of the work, you might get copyright infringement over like 3 minutes over the heart of the work versus 30 minutes of something that is just details about the work. So that's the amount of the work used. And the last one is the effect of the marketplace. So this would be about, does it adversely affect how much money the copyright owner can earn from selling or licensing their work? So for example, if you are going to be making copies of a book, then that means that the copyright owner isn't going to be making money from the sales of those books. So that's the effect of the marketplace there. So these are the 4 factors to consider in fair use. And besides that, always give credit. So giving credit, you've probably heard this before, cite your sources. Because after you determine what information you'll be using, you need to say where you got your information from. So like, what's the title? Where was the information found? Who created the information? When was the information created? Make citations. So for example, earlier in my presentation, I did use this right here about identifying how you can get permission to use copyright. I have right here, I got it from Copyright Allowance. They published it in 2023. It would be an example of like an in-text citation. I also, if you noticed earlier, had this right there. This is the full citation, and I have it done in APA formatting. And you know that you have APA formatting and you have MLA formatting. Just make sure you choose the formatting you need for your citations. Failure to properly cite your sources is plagiarism. And y'all probably have heard that before. Plagiarism, not great. Copyright infringement and plagiarism have a lot of overlap. Copyright infringement is when you take or use a work without permission, and that's a huge legal issue. Whereas plagiarism is when you don't say where you got your work from, and that's more of a moral issue. And when you do both, that's when you take permission, when you take it without permission and don't say where you got it from. Both are bad, but this is the huge difference between them. And Here is my works cited about where I got some of the diagrams